Hey, gun people! Day 10 of the trial. I'm not counting the weekend. Day 9 was last Friday. So this is day 10 of the actual trial where they're in trial. If they go to Saturday, I'll count it. But otherwise, these are just 10 days. So they're arguing about jury instructions. This is kind of usually boring. They'll go back and forth about who's okay with what and what I don't want read and I want this and all this. So I'm going to speed it up and go through this kind of quickly because, I mean, you're going to hear all these jury instructions again. Maybe I just won't cover that. I'll just go straight to closing. So I'm going to pick up the normal 1.5 speed here. All right, here we go.
I have sent proposal, or draft number 3 of the instructions to the attorneys this morning. And we'll make a record now on... Oh, would you put some of my pressure, please? Has everybody received a copy of draft number 3 of the proposed instructions?
Yes. Yes, Your Honor.
And state objections? Requests?
We have no objection. I know the defense has asked that the self-defense instruction be read with every count which is applicable. If they're asking for that out of an abundance of caution, we would agree with that request.
All right, what about that?
Look at the weasel.
Well, Judge, we've had, we've all talked about things off the record in terms of our jury conference. I was under the impression that that was a requirement. I understand we're trying to streamline it. We're trying to not bore the jury.
I'm wondering if he's being so quiet and so not getting anything on a record from him so he can later file a complaint and say he felt so intimidated that he could not do his job because the judge was so mean to him. Because that's how lawyers, they set things up like that. So his manipulation, again, he's the DA, he's the governor, he's untouchable, or he works for the government, he thinks he's untouchable. He knows he's got immunity, and how dare anybody tell him to be quiet or correct him. So he will get back and hold a grudge because he wants to destroy anybody that doesn't feed his ego. So I'm wondering if this isn't a setup for him being so quiet.
With the instructions, I think that is, and if I'm wrong, I'm wrong, but I think that is what the law requires.
I inquired on the message last night. Is anybody familiar with authority on this subject that requires that? It makes... I guess I'll argue with you and then I'll hear the rest of what you have to say. You know, attention span, as you know, you speak to juries all the time. And when you start repeating yourself, you lose your audience mighty fast. They've got a lot to hear today.
If you ever sit in a jury when they're hearing all this BS, you can just see them tuning out. They'll start doodling. Some will be taking notes. I mean, it's just... You can just totally tell they are so tired. I mean, they've been hearing all this mumbo jumbo all this time. You've been telling them it's about the case and the evidence, and now you're going to talk to them a full day on rules and crap that they can and can't do, what they must consider, must not consider, have to consider, what the law allows and not. I mean, it's just, you know, it's just crazy that we set jurors up to fail and then complain when they give us bad verdicts.
From me and from you lawyers. And if I am reading the self-defense instructions 5 times, I would expect to lose the audience rather rapidly. And
okay, so it sounds like what the defense wants is him to read the self-defense instruction behind every charge or crime. And that means they've got to hear it. So maybe if they hear it 5 times, they'll ignore it completely because they heard it too much. I don't know if that's true, I'm not sure if it was up to me whether I'd have it read 5 times or just parts of it some of the time and go through it at the first one and at the last one completely, but in between just touch on it. But it sounds like they want it read completely 5 times for something, I'm assuming for each charge.
This is so typical of lawyers who are hidebound. Well, we've always done it this way. And I will tell you that for years I have taken out common elements of things and put them in separate areas of the instructions. And I've never gotten even better briefly and concisely than by repeating the same old stuff over and over again. A mental waste of time and may end up having a negative effect. But, you know, I'm not going to mess around with a case of this magnitude over 2 days or 2 weeks to try. So if you think that risks everything to proceed.
When he says a case of this magnitude, it's kind of funny. There's a guy going on trial in Dallas right now who broke into homes and raped and killed, or Did he rape him? He killed him. I don't know if he attempted to rape or what, but he stole all their stuff and he killed them before he stole all their stuff. And he did it multiple times. And his trial is starting in Dallas today. And he faces the same penalty as this kid. He's not facing a death penalty. He's facing life without parole, the rest of his life in jail. He's got a rap sheet 10 miles long. And he's killing old women just to steal their property. And he's facing the same time as a kid that goes out there to remove graffiti and to protect a business and gets attacked and is a victim. Don't forget, Kyle is a victim. You know, when a woman gets raped, they say, oh, it's unfair for the prosecution to re-victimize her. Kyle was a victim. And now he's being victimized by the government again. And his whole life is in jeopardy. Facing the same penalty as a guy that broke into homes and killed people just to steal their stuff. That's what kind of guy Kyle is, because he's going to get the same penalty. Outrageous, this trial.
Proceed as I've suggested, then we'll go with the long forms every time. I'm going to have to count on you to make timely objection if you feel that I'm leaving something out on a particular count, because I've prepared it in the 36 pages of instructions. I've prepared them.
36 pages he's got to read to the jury. 36 pages. Oh yeah, they're just going to see this clear as mud.
Using a brief form without...
I've been in trials where the jury instructions were like 60, 70 pages. It's crazy.
There's already plenty of repeating going on, but if I have to do it longer, you're going to have to object if you think I'm missing something, or it's going to be a waiver, just so you're forewarned. You have to make a contemporaneous objection. Is that clear?
It is, sir. And
All
the
right.
only one that you don't have it in it that we had talked about a little bit was count 5. There's a lesser included offense of recklessly endangering safety.
Oh, yeah, I'm sorry. On that one, I do think that, well, no, I didn't put it in there, although it does in the final sentence. It says they have to be satisfied beyond a reasonable doubt of that the defendant was not acting lawfully in self-defense. But I'll try to squeeze the content in there as well. And I guess I'm not sure that I agree with your statement that, well, let's take a look at it. Repeat every time, retreat and provocation, which you have opposed.
They don't.
So they're going to hear that again. What?
They don't want that anymore.
They don't want it anymore?
I'm going to throw that request simply because of time.
Okay. I think I'll go back to bed. Okay.
I don't know why the time is off on this video. I'm getting a delay from them. It's not me.
But in counts 2 and 3, I gave special instruction only with respect to Mr. Mcginnis, because the law is different with respect to him. And we'll get to that. But I didn't reread it with respect to the account involving Mr. Jumpsuit Man.
The one that I think is where, so you've done attempted first degree with self-defense, attempted second degree with self-defense. But the way that I read it, if I'm reading it wrong, I know the court will correct me, on page 27 of the final
pause
instructions.
this and refresh it. Okay, where I rebooted it, kind of fix it.
Degree attempt. I don't know if I'm right.
And
So
that's because that's from the pattern instruction. I understand you're thinking, well, because I didn't discuss it in the portion on reckless endangerment, that they're going to think it's not part of it. But the last sentence tells them, and if you were satisfied beyond a reasonable doubt that the defendant's conduct was not privileged under the law of self-defense, you should find the defendant guilty.
Can you see that under the recklessly endangering safety one, Your Honor? Is that what I'm just making? Is that what you're saying?
That's on the, yeah, that's on, excuse me, I'm reading the fourth count here. Let's see, let's have a look at what I said on 5. If I had set this up, I would have put a, well, I'm not going to say what I would have done. So what you wanted, did you want the whole self-defense instruction discussed again, or just the clause? And that if you are not satisfied beyond a reasonable doubt that the defendant, or that I should say it, is all 3 elements of the crime of endangering safety.
How many of y'all are already bored and he hasn't even read everything he's got? He hasn't read 36 pages. They're just arguing on different things. But remember, you pesky citizens, ignorance of the law is no excuse. You're supposed to know every law and everything. All right? It's incumbent on you to know all the laws. So anyway, I did want to correct one thing that I said. I said the judge could overturn the verdict. And I guess, I said I've never seen him overturn a not guilty verdict. I've only seen him overturn a guilty. And somebody said that he can't overturn a not guilty verdict. And I looked it up to try and find a site because I don't like repeating stuff unless I can see the rule somewhere in some legal statute. And I asked people to post it, and nobody's posted it. I have found 4 or 5 sources that says he cannot overturn a not guilty verdict because it violates the defendant's right to a jury of his peers, which kind of makes sense. Although I can't find a legal site for it, I think that's probably true. So he can turn over a guilty verdict because he doesn't think the evidence was there and the jury was either confused or made a bad call, and it's unfair for a guy to go to prison when he's obviously not guilty. So he can overturn a guilty. He cannot, I'm pretty sure, he cannot overturn a not guilty.
Of the first degree have been proved, and that the defendant is not privileged under the law of self-defense, you must find the defendant not guilty.
I think that's fine as long as
You don't need the whole,
as long as they're aware that
the whole
self-defense is
instruction.
an option.
Yeah, well, you're right. All right, I'm just misunderstanding what your email said. So,
How many people are getting paid by the government right now to listen to this? Judge, court clerk, stenographer, bailiffs, 2 defense attorneys, 2 investigators that are sitting, or 2 prosecutors, 2 defense attorneys, 2 investigators that are sitting with the prosecutors. Who else is listening to this? I mean, this is all the salaries and money and benefits for court. Like I said, if we really put people away who were criminal and constantly in the court, we wouldn't need so much government. But that wouldn't benefit government, now would it? Anyway, I digress.
if you are not satisfied beyond a reasonable doubt, if you are satisfied. All right, so it'll read, at page 27, the fourth line will be, if you are satisfied that all 3 elements of the crime of reckless endangerment have been proved, and that the conduct of the defendant was not privileged under the law of self-defense, then you should find the defendant guilty of reckless endangerment of the first degree as charged as submitted. If you are not so satisfied, then you must find the defendant not guilty.
Okay.
Does that sound?
Remember, 35 pages he's got right here. I have seen appeals because the judge misread and misstated one of the jury instructions that the jury came back with a verdict on, and that was cause for appeal because he misread or misquoted the jury instruction.
Satisfactory? Okay. What's next?
I have nothing else on the instructions.
Defense?
Preliminarily, you had talked a little bit about the Richie Mcginnis instruction,
Right.
Which is on page 8 and 9.
Right.
And the position that I had taken was one of the lines says, but the defendant does not have a privilege of self-defense as to Richard Mcginnis. After that, there's discussion about self-defense and what that means. On page 9, there's a sentence that says, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. I had told you in an email that all the parties were involved in, and I thought that there was some incongruence in that in terms of how that reads. I know the court disagrees, but just for the record, I wanted to make sure that that was on there. Because I do think it's confusing. However, I know it's the pattern instruction. I know you took it from the pattern.
Yeah, I'm not going to argue with you. It is the pattern, and I'm not going to argue with you that it is confusing. But it's an accurate statement of the law. Mr. Mcginnis does not have a self-defense status because the defendant has no right of self-defense as to any harm he would cause to Mr. Mcginnis. And that's what the instruction is telling the jury. But if he was acting lawfully in self-defense with respect to Mr. Rosenbaum, then it kills one of the elements.
How can anybody say that he wasn't acting in self-defense when he was hit in the head, kicked in the face after he was knocked down after being hit in the head, hit in the back of the head while running with a rock that somebody was holding, a bag, which we still don't know what was in it when it was thrown at him, and cornered, and had 2 different people try to disarm him and steal his firearm. When you steal something from someone or attempt to take their property, that's called strong arm robbery. That's a felony. Everybody that tried to take his gun was committing strong arm robbery, and he defended his property and his life. and he's facing life in prison. Wow.
I think I'm reading that right. It gives him an absolution with respect to the element of what is the precise element? It says then the jury can't find it. Well, if they can't find that, they can't find one of the elements, so they have to find the defendant not guilty.
Judge, do you think it's appropriate then on page 9 to say if the defendant was acting lawfully in self-defense as it relates to Joseph Rosenbaum?
What point do you want that put in?
I just think that makes it clearer. I
Where do you want to put in?
Where did you say?
Yeah.
On page 9, it would be right, so there's a subheading determining whether the beliefs were reasonable. I think it's the third or fourth, the last sentence says, if the defendant was acting lawfully in self-defense, comma,
Okay, with respect to
Joseph Rosenbaum.
With respect to Joseph Rosenbaum.
His conduct did not create an unreasonable risk to Richard Mcginnis.
Yeah, I'll do that. Any objection?
No.
Okay. Okay, what's next?
Just, Your Honor, that on page, these are small, but on page 34, two of the witnesses, you said one of the witnesses had been convicted of a crime. Mr. Grosskreutz had been convicted of a crime, and Mr. Smith had been convicted of a crime. That's for a juvenile adjudication. So I think if you just say multiple witnesses had been, something like that.
Okay.
Um,
What page is that on?
I'm sorry, 34. And we are asking for the caution.
You want the word some instead of one?
Or multiple? Yeah, some is
Several?
fine.
How many was it? 2.
That I recall.
There actually were. Well, I don't think you asked Ms. Sword about hers. There was another witness with convictions, but I don't believe the question was asked. So 2.
What was?
So 3 of the witnesses were committed or convicted of crimes. But since the question wasn't asked on one of them, they're only going to talk about 2. Even though the one that was committed testified, because the question wasn't asked, he didn't read it.
What's the answer? All right, I'll put down 2 then.
And then there were some conversations regarding a cautionary instruction regarding Mr. Armstrong.
Yeah, and I really struggled with it.
And we had proposed the instruction to the court, which I think we took off at 245 or something like
Yeah.
that. So we are asking, based on his testimony, that the court instruct with that modified 245 instruction as it relates to Mr. Armstrong.
Did you want to be heard?
Well, I would stand by what I indicated over the weekend in my email, but I believe that I'm looking at the specific instruction. Say 245?
I think it's
That's testimony of accomplices.
Yeah, and that's a good model for it. That was what I had planned on using if I had drafted it myself.
Judge, I just don't think it's necessary. The evidence was received. The points that the defense wanted to get into were made on cross-examination. Giving any kind of instruction on this would essentially be telling the fact finders how to weigh the evidence. I proposed some different wording.
When he says the fact finders, he's talking about the jury.
You should not base a verdict of guilty upon it alone unless after consideration of all the evidence you were satisfied beyond a reasonable doubt that the defendant is guilty is completely inappropriate. I can understand where it's appropriate if you're talking about accomplices, but certainly not when we're talking about a one picture out of 100 and some odd exhibits. So I don't believe it's appropriate. I don't believe it's necessary. I believe that these arguments about pixels and zooming are specious, that their expert used a very similar software program with zooming was cropping.
There was no objection then. You see,
I understand. There's no basis for an objection, and they know that.
I don't know. I don't know that. Maybe they do. I don't know. I can't read their minds.
This is a forensically sound program used by a forensic analyst who's trained. This image was peer-reviewed. If they want to discuss the proprietary algorithms and how...
He loves saying that peer review and scientific, like that's the... If it's peer review, it must be right? Because if you ask 5 cops if the cop was not guilty and they say it's not, then he was peer reviewed. That's what he's talking about, peer reviewed. Yeah, this guy says someone else in his office with the same training as him reviews his work. And now they're passing this off as some sort of wonderful, freaking, well-accepted Einstein theory because somebody in the office reviews his work. Therefore, it must be fact.
An analyst would not know a proprietary algorithm contained in the software that they are using that is an industry standard. They can go ahead and argue that. But to give an instruction that tells the jury essentially to ignore this evidence unless everything else proves it is way too far.
Well, this whole business about, well, I don't want to say the whole business, but the Daubert rule is the product.
When he said whole business, he kind of meant, it's kind of bullshit, but he pulled it back,
Of the abuse of so-called scientific evidence by attorneys. Business about, well, I don't want to say the whole business, but the Daubert rule is the product.
What was the rule he said? The carpet rule? I can't hear what he said.
Business about, well, I don't want to say the whole business, but the Daubert rule is the product of the abuse of so-called scientific evidence by attorneys.
Dobler rule. Huh. Let me see what that is. Okay, I think he was talking about the Daubert rule and, you know, the rule of evidence regarding expert witness testimony, scientific, Daubert versus pharmaceuticals, federal rules of evidence, rule 702, definition, judges gatekeeper, rule 702, rules of evidence, assuring scientific expert testimony truly proceeds from scientific knowledge rests on a judge. So the judge is right. He has to agree that any scientific excellence does really rest in scientific knowledge and isn't just voodoo. And if either side can't prove that there's scientific evidence behind it to get the judge convinced, then they can't tell the jury. This requires the judge to ensure expert testimony relevant task at hand, reliable. Concerns about expert testimony cannot simply be referred to the jury as a question of weight. Furthermore, the admissibility of expert testimony is ruled by 104A, not 104B. Oh, that clears it up. Thus, the judge must find it more likely than not that the expert's method are reliable and reliably applied to the facts at hand. A conclusion of this, let's see, illustrative factors, theory, testimony of experts. I kind of want to hang on, let me find out what this was about. Oh, okay, I got a little better understanding. I just kind of breezed through this. So prior to Daubert, they used the Fry test, which was the standards for determining admissibility of evidence. And what was it? General practice? Gained general acceptance in particular fields in which it belongs. So that was the standard. So DAs abused this and just started putting everything, oh, it's general practice, general practice, general practice. So when Daubert got his case, he ruled that it could be abused by prosecutors, so they raised the standard and they made it higher for judges to differentiate between general practice, or the judge has to figure out it really is scientific, backed up by, what do they say? I forgot the words. Daubert hearings can be subject to abuses by attorney. These tactics range. Costs, a different pattern was done. Scientific methods of evidence. I thought it used some sort of like CSI terminology when they find it now. Scientific matters. Whatever. Y'all might have seen it. All right, let's get back to the trial. I just want to kind of clear that up when they use terms that I don't know. I like to figure out what they're talking about.
There were companies, pension funds, individuals were bankrupted because of legal decisions that were made on the basis of so-called science, which was later shown to be garbage.
Wow, sounds like he's talking about the CDC. Oh, shit, I can't say that. YouTube will be all upset.
When you come in here and you tell me, well, this is what they rely on, I think that's fine, except when my common sense tells me, well, wait a minute, what's happening here? When you get an image that is consistent of, I'll say it again, let's say 2,500 pixels, and you blow it up to 25,000 or 250,000, and you don't really know what fills the vacant space, that's a little struggle for me. And this is not being used to decide which camera I'm going to buy or which phone I'm going to buy when I'm at the store. This is being used to decide about whether someone's innocent or guilty of a crime. So that's why I was when the witness answered, he didn't know. And the only reason I left here and I troubled about it, and in the end, I decided, well, wait a minute.
Judges don't like to get overturned on appeal. So they like to cover their ass. So they try to do things to where they can't be overturned. So that's why judges are so careful about some of the things they do. If they think it can be overturned. Now, they still do stupid shit that they think they can get away with. And then once they're overturned, then all the other judges goes, oh, shit, we can't do that anymore. Kind of like cops ramming people. I'm about to do a case where a New York trooper killed an 11-year-old girl because he pitted him and turned her car over and she died. But cops have been pitting people all the time. But you know what? When somebody dies, now all of a sudden it'll be like, oh, we can't do that anymore.
allow this kind of thing to happen in DWI cases where the officer is asked, well, how does the machine work? I don't know. I just am trained how to operate it. But there is a difference there. That has already passed judicial scrutiny.
The problem with the DUI machine, when a cop is asked, how does the system work? We say, we go through training on how to operate it. We go through training on how to calibrate it. If the calibration is right, then we give the test, and this is the result. The system is certified every week or bi-weekly or bi-monthly by a certified technician that comes in and tests it. We have records to back up that it was cared for and tested by these records. And if they want to know more, then they call in the designer or the specific expert on that machine. So that's different. The state hasn't called in somebody specifically testifying scientifically what pixels are added, how they're added, where they're added, how many are added. Does it change the actual picture itself by blending and making it look like what the IA or AI thinks it is, or what the AI predicts it should be? So nobody's testified to that. So I think this is a legitimate objection.
And this method has been judicially determined to be accurate. Has that been done in this? I don't know. So that was when I was thinking, well, maybe I should give a cautionary instruction. I ultimately, you convinced me in our exchanges that I don't want to be meddling and commenting on the evidence. I will tell you this: assuming that there's conviction, one or more, assuming that other motions don't contaminate the whatever outcome there is, if it comes out at some time that the method used produces unreliable results, this is going to fall like a house of cards.
Meaning it's going to get overturned.
Because you're basing this extremely important segment of the evidence on something that I'm really queasy about.
So when this case is heard by an appellate court, and it will be almost all big cases that I think that they appeal, when this is held by an appellate court, if the judges on that appellate court say, you know what, this was a big deal, and the judge was right, and the prosecution knew what they were doing, and they did it anyway. Because sometimes when they overthrow an appeal, it's almost like punitive. It's kind of like the exclusionary rule for evidence for cops. If I go get evidence illegally, the DA can't use it. The court excludes it, and it says, you know what? This is punishment. You can't use it. It's called fruits of the poisonous tree. If I do something bad and plant a bad seed, any fruits that seed produces later is no good. So if I unlawfully enter a house and I find drugs, gun, money, dead bodies, none of that can be used because I was unlawfully in the house. So that's what he's warning them about.
But as I said when I left here Friday, this is the jury's case. It's not mine. And I'm going to let them decide. They have your photographs and your video, and they've got the testimony of the person who's worked with it, who knows a lot more about this stuff than I do. So I've decided to leave it alone. So I'm not going to give an instruction on it, but I've made my record on the high risk that I think it presents.
I'm pretty sure that the defense is going to mention this, or they should. They haven't done a lot of things that they should have done. They should mention this in there. You're going to, there was evidence about a picture being blown up, and you heard the witness testify. He does not know what is filled in or whatever. Now, the prosecution is going to be saying something like, it's tested and it's peer-reviewed, but that doesn't matter. We still don't know how that picture is changed, so that picture you're looking at is not necessarily the picture that was taken. Hopefully they will put something like that in their closing.
That's for the case. Okay, what's next?
The two last things, Judge. The court had modified a little bit count 6, which was the... Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches.
I didn't know they added that charge of an unlawful weapon. They never proved that. Did he say they added a charge?
Count 6, which was the... Okay, so the third element that you have listed there is the dangerous weapon was a rifle that had a barrel length of less than 16 inches or an overall length of less than 26 inches. We have pulled the transcript, talked, and looked at it. Detective Antaramian was asked if this was a short-barreled rifle. He had answered no, he did not believe that it was. That's the only information regarding
Was
that.
the gun offered as an exhibit?
Yes.
That is evidence.
Correct.
Enough in itself. The jury can measure it.
Okay. Fair enough. I just didn't... The way that I looked at it, there was no other information.
Yeah, the jury can measure it, but will they? It will take one juror there to go, they said this barrel's too long. Let's measure this. Some juries may not do it. It should be clear before the jury gets it. You shouldn't put the onus on them to do your investigative work. The freaking prosecution should have measured it. The defense should have measured it. And now you're saying, the jury can do it. That's bullshit.
That a reasonable juror could believe that count 3's been met. So
what are you telling me?
That I'm asking that you take it from them.
You're asking me to dismiss the case for failure to prove.
This count 6. Judge,
Count 6.
there have been many discussions about this count. I'm not going to rehash everything. The state disagrees with the interpretation the court has established. We do not believe the jury instruction is appropriate. We do not believe that the exception or affirmative defense, or whatever you want to call it, was properly raised. We argued about all that on Friday. I'm not going to rehash it. I believe it should go to the jury, and if the jury believes that it was not proven beyond a reasonable doubt, they can return a verdict on that.
See, this is sleazy shit by the DA. They know it's bullshit, but they also know that a lot of jurors get confused easy and they may fall on our side. The DA has nothing to lose by putting bad evidence in front of the jury. Nothing. So that's why he's arguing. That's why I said these two guys are the most unethical people I've seen. They are not about giving the jury a fair chance or giving this kid a fair trial or conducting things fairly. They are about confusing and trying to get lucky with the jury, and it's bullshit.
But the state has objected all along, or has given its version all along. We stand by that version. I believe that this jury instruction essentially swallows the entire statute. We've gone over that before. So I believe that if they raise an exception, then it should go to the jury. We would like the standard instruction. Clearly, the court's not going to do that.
See, he's like, it should go to the jury even if they raise a thing. Again, because it can confuse the jury. Why doesn't the judge hear the objection and rule on it that it's good or it isn't? That's bullshit. These freaking DAs are so crooked and they are getting away with so much in this trial. It's outrageous.
Well, up to now, the motions were motions to dismiss the complaint. And you filed a very nice brief, which well explained what the law is. And of course, we were dealing with what the complaint stated and whether the complaint stated sufficient facts to bring the case to court. And the court is confined on that kind of a motion to what's in the complaint and whether it meets the law. And as you pointed out, these offensive matters are affirmative defenses, and the DA doesn't have to plead them. So that's why I ultimately denied the motion to dismiss, although I think it ought to have been mighty clear that I had big problems with this statute. I made no bones about that from the beginning. And there always was access to the Court of Appeals all along here. Well, I guess that's not fair for me to say because I was sitting on it. But so shame on me. But I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense. But there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it or...
Amen! Thank you! Why don't you measure the damn thing? I mean, it's just crazy. It's just so easy. And what does the DA wants to do? Let's just give it to the jury and let's not do it. Let's leave it vague so maybe we'll get lucky. That is just so unethical. People are like cracking on me because I'm hard on these DAs. These people have the ultimate power to take someone's life, get them the death penalty, put them away for the rest of their life, basically ruin their entire life because they can, not because it's the right thing. That's bullshit.
You can stipulate that it does not meet what I've stated are the requirements. And if it is out of compliance, if the barrel length is less than 60 inches or an overall length of...
He bought it from a gun store. That is not a short-barreled rifle unless he modified it. I guarantee you that gun's legal. He bought it from a gun store. So all this is smoke and mirror bullshit. Measure the thing and move on.
Less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel length is appropriate.
Oh my God, did you just hear that? They know the gun's legal and they're still trying to pull this shit. And people are getting me. Man, why are you so rough on the DAs? They're defending the poor dead people. You know, the poor dead guys that died. The poor dead guys were all committing crimes. They were committing felonies. Oh my God.
Isn't it legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes.
Either by barrel or by...
Look at him. He can't even say it's legal. Can you believe that? The judge just asked him flat out, and he's like, the gun is not a... he can't even say, yes, the gun... He's saying it's legal. The judge, I think, just wants him to say it because he's being all, freaking lying and like he wants to confuse the jury. Listen to his response when he questions him. His answer on, we are not disputing some shit.
or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
So right here, the DA knows shit. If he measures it, he's going to know we know. We better tell him. The only reason they're doing this is because the judge pushed it. That's unethical. That's giving the jurors and the court, and it's misleading, and it's bullshit. These two DAs are freaking scum.
Not disputing that the barrel length is appropriate.
We are not disputing that the barrel is appropriate. Why don't you just say the gun's not illegal?
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes.
Either by barrel or by overall length?
Correct.
All right, and then...
So they knew. They freaking knew. And they sit here and lied and deceived and wanted the jury to get this bullshit. Outrageous.
Shotgun or a short-barreled rifle. Yes.
Either by barrel or by overall length?
Correct.
All right, and then count to 6 is dismissed.
Good for the judge. See, and the only reason justice prevailed here is because this judge, not all judges, this judge did the right thing. That's bullshit. Anybody that's not offended by what these two DAs just did, doesn't get it. Anybody that's not offended has never seen or had somebody they cared about convicted of a freaking crime where they shouldn't have been convicted because of bullshit like this from the district attorney.
What's next?
One other thing, I had filed on November 8th, we had addressed a motion for mistrial with prejudice. The court had taken it under advisement. What I had informed the court was, so I have filed something in writing on that. I know the court likely hasn't had an opportunity to review it. That's good, because just saying it in court is different than he was able to cite things when he filed it in writing, cite cases, cite the misconduct, he can spell it out. It gives the judge more stuff that if he does rule, he's like, how could I argue with this? And even if he doesn't rule, now he gets to put a more detailed things with case cites on why it was so inappropriate. So that was a good move, doing it in writing afterwards. I don't know. I'm assuming that we're going to go obviously through closing arguments today, but I did want to make sure the court was aware that it had been filed, and at some point have the court make a final ruling on it, just for the record.
I will.
Okay.
If it's necessary.
The fact that he hasn't ruled on it yet means he's probably not going to give them a mistrial. I mean, if it was egregious enough to do it, he wouldn't be wasting the jury's time. He wouldn't be going through all this, and he wouldn't give it to the jury if he had any intentions of dismissing it. So that's kind of a clue that he's not going to grant their dismissal or their mistrial. I mean, unless he reads it and they put one hell of a case together, then, I mean, he might. If they make it so overwhelming evidence that, look, this is absolutely wrong, and if you don't do this, you're going to get overturned appeal, then he would do it. But I doubt that's going to happen.
Okay. Came in this morning? Okay. Okay. Anything?
The Washington Post story.
I did receive that. I did receive that.
It relates to the motion. That's the reason I asked. The defense motion, it relates to that.
Well, I'm not going to take up the motion now.
I just knew there were technical problems. I just wanted to make sure they were in a note.
I did receive it. Okay. Anything else right now?
Judge, are you done? Attorney Charles. The only thing, Judge, in our arguments, we would like to indicate that pointing a loaded AR-15 at someone without reasonable justification would be a criminal act without citing, the specific statute, but that pointing under 941.20 is a crime.
It is not a crime if you're defending yourself or your property. If somebody comes in to rob you, you can point a gun at them. It's called armed robbery. If they're armed, you can point a gun at them. If they try to disarm you, you can point a gun at them. So just pointing a gun is not unlawful in itself. Again, more lies and deceit and confusion for the jury.
We would like to point that out, and we just want to preview that, so if there's objection, we can handle it now.
You want to respond?
Who would object? This is once again relying on the exhibit that is so far out of focus, and there's been nothing in the record. When I specifically asked the Detective Howard, regarding the strong arm robbery, I asked about it. Strong arm robbery while masked. I asked about it. It's in the record.
Oh, I didn't hear that. I must have missed that. He actually asked about strong arm robbery while masked. I totally missed that somehow.
The struggle I'm having with that is, and I will. Oh, I'll leave that. How do we know it was pointed at or toward Mr. Zeminski or Mrs. Zeminski or whomever?
Strong arm robbery is robbery through force or fear. Usually the definition of robbery is taking someone's personal property from their presence by the use of force or fear. And the common confusion is purse snatching. Purse snatching is not robbery unless the woman grabs her purse and hangs onto it, and it has to be struggled away from her. If a criminal comes up behind you, cuts your strap, and grabs your purse and runs away, and you're like, oh my God, he got my purse, that's not strong arm robbery. The court doesn't say he used force or fear because you didn't even know he took it, and he didn't have to struggle to get it. But if they grab it off your shoulder and you hang on to it and he pulls you, knocks you down, drags you, or you wrestle at all, now it's strong arm because he used force to get it from you. So when they put their hands on his gun, that's absolutely strong arm robbery.
You have a theory that it's pointed in that direction. I agree with that. But the statute's prohibition is pretty explicit. And I'm not sure that the evidence that you have, especially because it's just not just especially, but in part because it's just a regular photograph. It's not multidimensional. It doesn't show the exact area in which the firearm was aimed.
Good.
Even if you see the firearm.
Again, the photograph is perhaps the fifth or sixth most relevant piece of evidence on this topic.
Great. The most important relevant topic, evidence on your topic is freaking bullshit, and you didn't bring in an expert to validate it, to prove it beyond a reasonable doubt to the jury. You can't even prove it to the judge. You can't even prove it to them because you both are lying, sneaky, and you have no case, and you're pathetic. And you both fit the stereotype of sleazy lawyers to a T. Except you work for the government. You're supposed to represent the people. You're paid by tax dollars. You're supposed to be getting justice, not taking advantage of people and sending people to prison that shouldn't be there. You freaking both are disgusting.
Most what?
Fifth or sixth most relevant piece of evidence on this topic. We have testimony, we have videos. I'm not going to go over that again. The defense submitted their own exhibit of the FBI video with the Zeminskis denoted as being the only two that were on that side of the Duramax. Mr. Zeminski starts out by one of the windows of the Duramax, I guess would be the rear passenger side window. And so there's no real dispute that they are in that area, and that is where we argue that he is pointing the weapon. It's for the jury to decide if he's pointing at Zeminski's or not.
And nobody here has raise your hand if you've never seen a cop point his gun at a crowd, at several people, in a store. I mean, look, I was a cop for 30 years. I'm telling you, I've pointed my guns at thousands of people. And never have I been in front of a judge saying, you endangered people by pointing a gun and it could be dangerous, whatever. And a lot of people, when I bring up cops, they want to say, why are you talking about cops? He's not a cop. There is no difference between use of force between cops and civilians. You have been programmed that there is, but there isn't. The only difference is a civilian is judged by the reasonable person standard, and a cop is judged by a reasonable cop with the same training and experience standard. That's the only difference. The rules are the same.
It's for the jury to decide. It is not for the jury to speculate. I mean, let's look at the statute. That's a good place to start.
He's looking up.
That brings up, a separate issue, I suppose, that what is the role of Mr. Rosenbaum, assuming the defendant violated that statute? That's the very theory that the state has proceeded on in the first place, is that the defendant was a vigilante who was getting himself involved in something that was not his concern. And now you're telling me that would justify Mr. Rosenbaum's actions? I'm kind of struggling with that, too. How would that justify? I mean,
that is the only way they can make this a crime, is if they say poor Rosenbaum was a victim. He was setting shit on fire, burning shit, cussing people, threatening to kill people, arming himself with a chain, had a bottle of mixed gas and chlorine and Clorox and all the other shit, but he was the victim. Really? Well, that's justice.
What does the jury do with that?
I don't fully understand the court's question. I would also
What
note that
is pardon me?
he also pointed the weapon to Mr. Rosenbaum before the shooting. While he's being pursued, he turns and points it.
Yeah, that was after Rosenbaum said, if I get you alone, I'm going to cut your throat and kill you. Most people would find that threatening. Not you two idiots. If somebody looks at you wrong, you would want to file charges that they threatened you. Freaking unethical pukes.
Mr. Rosenbaum.
Well, there's no question about that.
Correct.
That he's being chased by him.
Pardon me?
Is that he's being chased by him.
Well, they made it much more complicated. It used to be points or aims of firearm at another. I'm not seeing that exact language anymore, but I'm not seeing it here in the statute that there'd be a broad enough sweep to capture
Well, that'd be great, because that would give
some
her the
wrongfulness in
evidence.
just pointing the firearm towards the west without evidence that it was pointed specifically at or toward another. What am I missing?
1A is endangers another safety by the negligent operation or handling of a dangerous weapon.
Could you start that over? I'm sorry.
Sure. 1A is endangers another safety by the negligent operation or handling of a dangerous weapon. We would argue that it is. If the court feels otherwise, we just simply will talk about it and not call it.
Well, where was the firearm aimed? You say at the Zabinskis. I didn't hear the Zabinskis come in here and say that. Who said it?
Except for looking at the video, and that's who's over there. That would be the only
Okay,
evidence.
pardon?
Looking at videos and indicating that those are the ones who are over there, that would be the only evidence.
I can't say. I'm not saying it didn't happen. I'm saying I don't think I can give an instruction to the jury, telling them something when I don't see the statutory.
We're asking for instruction. In our closing, in our arguments, we just wanted to say that it's.
I think it would be okay for you to state what the law says, but you have to be careful because the jury cannot be invited to speculate. So I don't want to. There's such a universe of possible statements that could be made that I don't want to try to rule in advance. I've refrained from doing that. I always try to because I can't read your mind. But so I'm not going to say they can't mention that at all. That it's unlawful to point a gun at somebody. The juries probably have a sense of.
See, when you're doing your closing, you don't want an objection sustained because you're addressing the jury, and this is your last time to do it, except for the prosecution. Of course, they get 2 bites at the apple. But they don't want to be objected and sustained. So that's why they want to do all this before, so they don't get objected and it doesn't mess up their rhythm. If somebody's doing a closing and the other side is objecting every 2 minutes, they can't get in rhythm. And if they win 2 or 3 times, it makes them look like the liar they are. Kind of like the weasel here. But we'll see.
That anyway, but as to what might be said, I can't tell you what's in and out of bounds. Okay, what's next?
All we got.
So basically, he didn't rule on it. He said, I'm not going to tell you can't say it because you can say what you want because I don't want to restrict your closing. But if you say something and the prosecution or the defense can object, then I'm going to hear their objection. So be careful on how you pick your words, because once I hear the objection and then I hear what you said, I may sustain it. That's kind of what he just told him.
Okay, ready for the jury? I'll probably take a break after the lengthy instructions.